Okay, we're going to begin a new topic, and that's the contract liability of a principal. Now, just to give you a preview of how we're breaking this out, we began our discussion talking about how you create an agency. And the second thing we discussed was, once that agency has been created, what is the effect of it on the agent and the principal? We discussed fiduciary duties, that's the duties that are created as a consequence of an agency relationship. And now we're moving on to the topic of what happens with regard to the agency relationship and third parties. And by third parties, I mean not the agent, not the principal, but somebody else. What I want you to do right now in your mind is separate contract liability from tort liability. They're treated differently in terms of vicarious liability under the law of agency. So I want you to be really careful. If there is a common error on exams, it's that people use the tort agency rules for a contract problem or vice versa. So make sure right off the bat that you are in the right universe. Right now we're in the land of contracts. So we're going to begin talking about the principal's liability for contracts entered on their behalf by an agent. And in a separate podcast, we'll talk about the agent's liabilities on any such contracts. Here's the general rule. The principal is liable for a contract entered into by the agent on her behalf when, number one, there's an agent, and number two, the agent acted with authority. So you're looking for two things, an agent with authority. So that's your mantra, agent authority. There are a few different kinds of authority. There is authority that actually exists. In other words, it truly was given. The principal truly gave the agent authority to do something. Actual authority could be either express or implied. In other words, the principal specifically granted the authority to the agent, or it could have been implied under the circumstances, and you can see the rule here. Implied authority exists regarding any task reasonably necessary to effectuate the duties that were expressly granted. Factors that would be relevant would be course of conduct, what is typical in that industry or business practice, what history do they have together, was it an emergency or some other exigent circumstances. All of these factors would be relevant in determining whether an agent would reasonably imply that they had authority to do something. Now, while actual authority relates to the understanding between the principal and the agent, apparent authority doesn't actually exist. The principal did not give the agent authority to do some particular action. But apparent authority isn't related to actual authority. It relates to what a third party reasonably believes. If there's a cardinal rule in law, it's to protect the reasonable expectations of a third party. So in apparent authority, we treat it as if there was authority, if a third party reasonably believed that there was. And there's another concept. I'm going to use hypotheticals to show all of these. If it feels like a lot's been thrown at you quickly, I'm sorry. There's another concept I don't believe is in the textbook. It's called ostensible agency or agency by estoppel. What that means is someone appears to be an agent when, in fact, they're not. Okay, so now take actual authority separate from apparent authority and a real agent as opposed to someone who appears to be an agent, an ostensible agent. These are the concepts we're working with. Here's a hypothetical. Suppose that Jonathan calls his insurance agent Laura, and Laura answers the telephone. First Insurance Company, Laura Rivas speaking, and Jonathan asks for Laura to increase the liability policy on his car. Laura agrees to do that. Now first, let's assume that Jonathan asks Laura to increase the liability policy to a $1 million umbrella coverage. And let's suppose that Laura has been told by First Insurance Company that she's authorized to do this. She is authorized to issue $1 million umbrella policies. She tells yes, we're increasing your coverage to that amount. Okay, hypothetical number 1. Is the insurance company for whom Laura is an agent, is that company bound by that contract between Laura, their agent, and the third party Jonathan? And the answer is yes. Why? Because number 1, Laura is their agent, and number 2, Laura had authority. She was an actual agent. In other words, there was an agreement between Laura and First Insurance that she would act at the insurance company's benefit under their direction or control, so she was an agent, and she had authority to raise Jonathan's coverage. What kind of authority did she have in this hypothetical? She had express authority. The First Insurance Company specifically told Laura that she was authorized to raise the limits by that amount. So, she's an agent with actual authority, therefore, conclusion, the principal, i.e. the insurance company, is liable for that contract. Okay, hypothetical number 2. Let's assume the same facts. Laura is working for First Insurance Company. However, First Insurance Company has told Laura that she's not authorized to issue any umbrella insurance policies. Jonathan calls and asks for a $1 million umbrella policy, and Laura, despite being told specifically that she is not authorized to do this, tells Jonathan, yes, you're covered. Now, is First Insurance, the principal, liable for that contract entered into by their agent Laura? Well, let's go to the test. Number 1, do we have an agent who, number 2, had authority? As we discussed before, Laura is their actual agent, so part 1 is satisfied. Part 2, did she have authority? Did she have actual authority? No. The insurance company specifically told Laura that she did not have authority to issue this kind of policy. However, did she have apparent authority? Maybe. The test for apparent authority is, would a reasonable third person believe that the agent actually had authority? If you were a customer and you called up the authorized agent for the insurance company and asked for increased coverage, would you assume that the agent had authority to do that? The answer is probably going to be yes. This is a pretty routine matter. So, is First Insurance Company liable for this contract? The answer is yes. Laura was their agent who had apparent authority to bind the principal. Jonathan is protected because we protect the conduct of reasonable third persons. Notice also that the courts often put the burden on the party who had the greatest power to have prevented the problem. In this hypothetical, who had a greater power to prevent Laura from making an unauthorized representation? Jonathan, the customer, or First Insurance, the principal? Certainly it's going to be the insurance company, and therefore many courts reason they should bear the cost of an agent who disobeys instructions. Now, hypothetical number 3. Jonathan calls the insurance agent and Laura's daughter answers. And although Laura's daughter is really named Teresa, Teresa is being a real brat and says, First Insurance Company, Laura Rivas speaking. Okay, now same thing. Jonathan asks for an increased policy, and Teresa says, yes, we have coverage for that. Here's what the rate would be. She sounds very professional. She sounds very official. She sounds just like you would expect someone to sound. Now, is First Insurance Company bound by this unauthorized contract? Number 1, do we have an agent? Was there an agency agreement between First Insurance and Laura's daughter, Teresa? No, they don't even know who she is. However, if the principal cloaks someone with the appearance that they are an agent, even when they're not, and the appearance that there is authority, even though it does not exist, the principal can be held liable. How? Well, the problem is Teresa, Laura's daughter, is acting as an ostensible agent for the insurance company. Ostensible agency is really the same test as authority. Would a reasonable third person believe that this person had authority and was an agent? Let's look at the facts. Jonathan called the First Insurance phone number. This person identified herself as someone Jonathan knows to be their agent. This person sounds professional, knew the policy rates, or at least appeared to, and knew the language in that industry. It sounded like this was official. So it looks like Teresa was an ostensible agent for First Insurance Company. So there is an agent, ostensibly. Is there authority? Well, again, apparently there was authority. This is a routine kind of inquiry. An agent does have such authority to raise policy limits often, so a jury would probably find that there was an ostensible agency with apparent authority holding First Insurance Company liable. You'll see from the language in the textbook that apparent authority and also ostensible agency exist only through the principal's conduct. Here, however, the principal did cloak an agent with authority because they're using the principal's facilities. They have access to the principal's phone, access to the principal's information. This really is the principal cloaking someone with their authority, when, in fact, they have none. So, as between Jonathan, the third party, and the insurance company, who had a greater ability to have prevented this mess in the first place? Again, the courts would put the burden on the principal, so Jonathan is protected. Here are a couple other theories you should know about. One is ratification. Ratification is a concept that applies to a lot of circumstances, not just agency. It exists when someone is not bound to a contract, however, they agree to be bound. What are the requirements? It requires, in the context of agency, that the principal knows all the material terms of the contract and affirms the contract. Again, material means significant, or terms that would affect the decision to enter a contract or the price. And affirms the contract, what does that mean? That means you acted like you wanted to be bound by the contract. You signed off on it, you accepted the benefit for it, or you did something else that looks like you're agreeing to be bound by a contract, although you did not authorize it. Ratification can be express or implied through words or in conduct. So now let's go back to our previous hypothetical. Suppose Jonathan calls the First Insurance Company and Laura, not the daughter, but Laura answers the phone, First Insurance Company, Laura Rivas speaking. And Jonathan asks for the $1 million insurance policy, and Laura says, gosh, I'm really not supposed to do that. They've told me not to issue these policies anymore, but let's just put it through and let's see what happens. She puts through the paperwork and Jonathan pays for the increased policy. Now, is First Insurance Company bound? At first, it looks like now they know all the material terms. The contract was certainly not authorized. Jonathan certainly couldn't believe it was authorized because Laura told him it wasn't. What could the insurance company do to ratify this unauthorized contract? Well, they get in the paperwork and they accept the payment. A court would say it was an unauthorized contract, that First Insurance Company did not have to honor the agreement. However, they chose to. That's ratification. Another concept, and I don't believe it's in the book, is called estoppel. Estoppel, and we've come across this word before, but it has the same word source as stop. And it means stop, shut up. Even though everything you are saying is true, you should not be permitted at this late point in the game to come in and make the assertions you're making, despite the fact that they're true. This doctrine is rarely used, but it is possible. I can give you an example of a case where here's what happened. There was someone who managed a store. He was an employee and he was a crook. And when customers would return an item to the store, he'd say, well, we have to reimburse you in a check, not cash. That's store policy. However, I can make it out to you and you can endorse it back to me personally, and then I can give you the cash. Would you like to do that? Well, guess what? A whole bunch of people preferred cash. So all of these customers were returning items to the store, and the manager would issue a check to that customer. The customer would endorse it over to cash, and the thief employee would pay that cash over from the register, and then the employee was taking the check over to a bank. And although it was issued to a customer and endorsed over to cash, He was taking this money for himself. In other words, not putting it in the store's bank account. And the bank permitted all of this. 11 years go by. This is a true case. $600,000 of fraudulent transactions. And finally, the store figures out that they're being robbed by this employee who has incidentally moved to, I don't know, Bahamas or someplace where he couldn't be reached. Now, the fight is between the store and the bank. Who's the victim here, the store or the bank? And the answer is, well, they're both victimized by this thief, but the thief is long gone. What are we going to do between two innocent parties? What the store was asserting is that although this manager was an agent, he did not have authority to do this. So remember, the store will be bound as long as the employee had authority. So they're saying the employee did not have authority to do this. He certainly had no actual authority. Did he have apparent authority? Could the bank reasonably assume that an employee of a store could come in with all these checks made out to cash all this time? It's a lot of money. Well, no. What a bank would reasonably assume is that the employee could have that money transferred to one of the bank's accounts, but not to himself personally. So did the agent have apparent authority? No. So on the face of it, is the store bound by this transaction entered by its agent? No. However, this went on for 11 years, hundreds and thousands of dollars, and the court looked at this and said, store, it's true you were victimized, but you went on for all this time not notifying the bank that all of this was unauthorized. You are estopped from now coming into court and claiming these were unauthorized transactions. Estoppel falls under is a doctrine under equity, and it's when it would be unfair to enforce the rules, even though those are the rules. And in a case like the one we're discussing, the court said, you sat on your rights for 11 years when any remotely competent business would have figured out this fraud. You cannot now come back and blame the bank for all of this. So, although this conduct was not authorized, you are estopped from asserting your rights. You should look at the doctrine of estoppel whenever it looks like, although what someone is saying is true, it may be profoundly unfair for them to come in now and make their claim. Our next topic is the effect of disclaimers. This one comes up a lot, and here's the problem. What happens in a case when the principal has said, now the agent's not authorized to do anything other than what's in the written agreement. Okay, so the agent is not authorized, and it is in this written agreement too. So despite that, the agent has told you he is authorized to do this. What's going to happen? Is there apparent authority or not? Is it reasonable for you to believe that an agent can do something when the written contract says that the agent isn't authorized? There's no clear answer to this. It depends on the circumstances. And the test is, would a reasonable third party believe that the agent had authority? Part of this goes back to the topic of communication. How prominent is that written disclaimer in the agreement? Would a reasonable person have read and understood it? Look at how sophisticated the customer was. What exactly did the agent say to them? The more sophisticated and educated the party, the more likely the court will hold them to the written disclaimer saying, you should have read the contract and understood the practice. An agent can't modify the terms of the written contract without changing that contract in writing, and therefore it's not reasonable that you thought they could do so. On the other hand, if you're talking about just a consumer contract that is often not read by a consumer, then there's an issue of whether the term was even communicated in the first place. The more complicated the language, the less likely a court is to hold a consumer to that written disclaimer. So in the world of black and white, this one's gray. Look at what is customary business practice. Look at the prominence of any written notice. Look at past experience, business practices. Look at the sophistication of the parties and ask yourself, would a jury of 12 people would they expect each person to have read and understood what the principal was saying, that the agent was not authorized to do anything that was not written in the agreement? If your answer is yes, then there's going to be liability despite that disclaimer. Here's a visual, and I hope it's helpful. It's a decision tree on figuring out how to solve these problems. Sometimes when you go into an exam, you get confused and nervous. So start at the beginning, and you're going to say, I'm looking at a contract problem. My first question is going to be, was there even an agency? If your answer is yes, your next question is going to be, did that agent have authority? If your answer is yes, then what kinds of authority exist? Actual, which can be express or implied, apparent. Then the answer is yes, the principal's liable. Now let's go back to where it says, yes, there's an agency, but no, the agent did not have authority. There was no actual authority, no apparent authority. Check for ratification or estoppel. Did the principal ratify this otherwise unauthorized contract? For example, by accepting payment or by signing off on an agreement to be bound? If your answer is yes, then the principal is liable. If your answer is no, the principal did not ratify the contract, and there's no estoppel, then the answer is no, the principal is not liable. There was an agent who did not have authority, no ratification, no estoppel, principal's not liable. The third party was not reasonable in relying on the agent. Now let's go back. Let's say your answer to was there an agency is no. Well, check to see whether there was an ostensible agent. If your answer is yes, then check to see whether there was apparent authority. And again, if the answer is yes, the principal could be liable. If your answer is no, then the principal is not liable. If there's no ostensible agent, then no, there's no vicarious liability. There's no agency, there's no ostensible agency. The end. You're done. There's no vicarious liability. Okay, I hope that's helpful. And we're finished with the topic of the principal's liability for a contract entered into by the agent. Our next topic is, when could an agent be liable for a contract entered on behalf of a principal?